Welcome to the Flex Your Rights podcast. I'm your host, Corey Hanrahan. This is the podcast for informing employees of their rights in California. So if you want to know your rights so that you can flex them at work, this is your show. Let's get flexing.
All right, everybody. Welcome back to the Flex Your Rights podcast. Corey Hanrahan here, Travis Triggs. We've taken a little bit of a break. We've been gone for a little while. We've been busy. But the good news is, the important news is we're back. So we are back. Travis and I sort of talked about what kind of episodes should we put out? What should we talk about? We've, covered some different topics. And we thought, why don't we talk about sort of the stages of a lawsuit? So if you are, it really applies to almost anyone, but if you're an employee who is suing their employer, I get the question a lot, right? What's going to happen? What comes first? What happens next? And so what do you think, Travis? Let's just talk about those stages so people kind of know what they're in for when they hop into that.
Yes, exactly. Because me being an employee at times of my life too, and just knowing a bunch of employees, knowing these things can help and give you the courage to either step up and speak to you, or just know exactly what to do when it's happening. So this is perfect. I think people are really going to appreciate this.
And look, let's sort of like take the fear out of it, right? Because I think a lot of people look at a lawsuit and they just become terrified immediately. Like it's going to be this scary situation. There's going to be all these horrible things that are going to happen. And it really isn't, you know what I mean? So let's explain so that people can feel comfortable flexing their rights, right?
Yes.
by letting you know what's going to happen.
Exactly.
By letting you know what's going to happen. So
let's get it, Corey. So it's the very first. So, Mr. Corey Hanrahan, what is the very first step in this process?
Get yourself a lawyer. So it would be hire a lawyer, right? If there's something going on at work, these are difficult cases to navigate. I don't think I've ever met a non-lawyer who could navigate them themselves. Even within like the lawyer realm, right? Lawyers who do not do employment cases can get tripped up on them sometimes. So, the first step would really be, get yourself a lawyer. Hire the right lawyer for you, one that feels like the right fit, and get the lawsuit prepared. So that's the first step, right? You're going to hire a lawyer. There's going to be a back and forth. I like to get, a detailed sort of timeline for my client of what happened at work so that I've got all the details, dates, as much information and detail as possible. I take that, I prepare the lawsuit. So step one is preparing the lawsuit. And as the employee, your job in that is pretty easy. You just tell your lawyer what happened, right? It's the lawyer's job to prepare the lawsuit. You don't have to know how to do it. And so you just tell them what happened. They turn that into the lawsuit and the lawsuit gets filed.
Okay. Now, how typically long does that process take?
It varies, right? It depends on how busy the lawyer is. It depends on how busy you are in getting them the information. For me, I like that to be done within a month. Month and a half, couple months. Now, if you're near the end of your statute of limitations, which means the deadline in which you have to file the lawsuit or you're precluded from doing it, then it could take a matter of days, right? Then the lawyer's got to jump into high gear and make sure that it gets filed on time. But, if you've got 3 years until it needs to be filed, there's no real rush to get it done right away. So, a month, couple months, that's not unusual, for it to take a, short period of time like that to get it done right and get it filed.
Okay. So perfect. So they hire a lawyer, they speak with you, they prepare their paperwork. They tell you exactly what happens. What's the next step after that?
So the next step is after the lawsuit's filed, you serve it on the other party, right? So that's where they find out, oh shoot, right? We're getting sued. And then at that point that they're served with the lawsuit, they've got, a certain amount of time to file a response, like an answer or to challenge the pleading or whatever. And that's really the pleading stage of litigation, right? Once they get their answer filed, then the pleading stage is done for the most part. And you move on to the discovery phase of litigation.
Okay. So the pleading stage is, and the pleading is when the person who is being sued, so the job, for say the owner of the business, that's when they're putting their case together to defend them, what they're being sued for. Is that correct?
Yes and no. They file an answer, right? An answer to the lawsuit, which is really in state court, it's anticlimactic. I mean, there's no real specific information in there. It's just all general defenses. I mean, they throw everything plus the kitchen sink in hopes that maybe they're able to find information down the road that would support one of those defenses.
Okay.
So that's the end of the pleading stage, right? You've got your complaint filed, they've got their answer filed, and then the pleading stage is essentially wrapped up, and you move into discovery.
Okay. Perfect. This is awesome. I hope this is making a lot of sense to you guys listening up right now. I hope it is. Oh, there it is. Currently, right now, we're getting some land cleaned up right now. The guys are in the yard, so pardon the noise.
Got some yard work, but hey, look, this is like the real deal, right? I mean, we don't edit stuff out. We don't sugarcoat it. So when there's maintenance noise and gardening going on in the background, hey, we've got maintenance and gardening noise going on in the background.
It's happening in real life.
There it is.
So after the pleading stage, there's a discovery stage. Now,
right.
What's after the discovery stage?
Well, let's explain the discovery stage a little bit.
Yeah.
Right. So let's talk about it first. So discovery stage is where each side gets to send out written questions to the other side. Right. So you get to send out written questions. You get to send out what are called requests for admission, saying admit this, and they either have to admit it or deny it. And you get to send out something saying, these are the documents that we believe that you have that we want you to turn over to us. Right. So that's where you're getting sort of, the factual information that's starting to form the facts of the lawsuit. So, for example, in an employment case, one of the questions I always have to ask is, tell me all the reasons why you terminated plaintiff's employment. Right. We would need to find out from them what their story and reason is going to be for firing my client. Right. We can also ask questions like, state all performance issues that plaintiff had during his or her employment. Identify all occasions where you talk to plaintiff about performance issues. You know what I mean? To try to show that they were not a bad performer, because sometimes they'll respond and they'll go, they weren't a bad performer. So then we can look at that and go, okay, so performance is really not going to be an issue in the lawsuit, right? And with the request for admissions, admit that you did not pay plaintiff, his or her final paycheck on the last day of employment, that kind of a thing. And then we can send out a question, state the date that you paid plaintiff his or her final wages. We can ask, in discovery, we can ask for documents showing write-ups during employment. You know what I mean? That the plaintiff was doing a bad job. So, we really get all of that information in writing, and the writing is verified by the parties, right? So the answers are actually verified by the parties, so they can be used against them as statements in the lawsuit.
Okay. Now, during the discovery, is it really the lawyers speaking with each other, or like the lawyer speaking with your client, and then it's like two separate parties, or is everyone coming together and discussing everything?
So there are kind of two different things in discovery that you can do. One is the written questions like we talked about. And those are just really the lawyers exchanging stuff, right?
Okay.
So, those questions get sent to me. I talk to the client, I get the answers, I prepare them in writing, they sign them, I send them back to the other side. So my client never talks to the other side. But after the written discovery, then there are depositions. So depositions are like what you see in the movies, right? Nobody puts written discovery in the movies to be boring. It'd just be some lawyer typing stuff up. So the depositions are actually where, we're in a conference room together. Me, my client, the defense attorney, could be somebody, from the employer, there as well. There's a court reporter. And depending on whose deposition it is, that's where the lawyer gets to ask the person questions directly. So that is like the unfiltered information from the client, which is my favorite part of the case, right? Because when I'm sending out those questions, the lawyers get to go, hey, what's a good answer to this? You know what I mean? And they get to sort of help form the answer in writing. But in that deposition, I get to grill maybe the supervisor who harassed my client or fired him or her. I get to grill that person and ask them the questions, and the answers come directly from them.
Oh, wow.
So they can't talk to the lawyer and go, hey, how do I answer this? They are on the spot at that point. So they have to answer the question for themselves and the lawyer cannot help them. They can object. They can make objections, but that person, it has to come straight from their mouth. And so that sometimes is a lot more beneficial than the written discovery.
And on those, you said they were called dispositions, correct?
Depositions.
So for the depositions, is that also where the jury is, or that's before you get to that?
That's before you get to that.
Okay.
So the purpose of the depositions is really to lock down that person's testimony so that you know what they're going to say at trial.
Okay.
Right. So, so when I'm in trial, right, and we'll jump forward to trial in a little bit, but I already have a booklet, a transcript of all the questions that I asked and the answers. So I know what they're going to say at trial.
Okay.
Right. So if I ask them a question and I go, in deposition, I go, did my client have any performance issues at all during her employment? And they go, no, I don't remember any. And then if we're at trial and I go, in fact, my client had no performance issues during her employment, correct? And if they go, no, that's not true. That's not true. She screwed a bunch of stuff up. I can go, oh, really? Hold on a second. And I can, and I've got citations to the transcript by those questions. So I know right where to go. And I go, Your Honor, I'd like to read from the witness's deposition at page 80, lines 8 through 12. Question: did my client have any performance issues during her employment? Answer: no, not that I can recall. So then the jury's going, shit, they're lying, right? I mean, when are they lying? They're lying then or they're lying now. But those answers don't match up. So that deposition testimony lets you hold them to their previous responses.
That's pretty cool.
because it's under oath. It's great, right?
Yeah.
And then they realize it after that first time, because I've had that in trial before, where all of a sudden, like, the witness is going,
yeah,
and then they know I got him, right? It's like, you better stop lying, because if you keep lying, I'm going to read from this deposition transcript as many times as I need to, so the jury knows that you've given two different stories.
And that's really what it is just finding the truth at the end of the day. You just want the truth.
You want the truth.
Yeah, exactly. I was gonna say, is it really visible when you have someone in the jury or in the deposition when they're sitting there? Is it obvious? Does face expressions or body movement, does that matter in those type of situations, or really just off what you say? Like, is it one of those, like, you can look the way he's acting, he looks very uncomfortable, he's possibly lying, but even though is that how that works, or it's not like that? Or,
I mean, it's a good question. To me, it doesn't work that way. I mean, to me, even somebody telling the truth, I mean, they're uncomfortable in deposition, because they're sitting there, they're in the hot seat being essentially interrogated by a lawyer. And so everybody's nervous, you know what I mean? In that situation. But yeah, the purpose though of that is just to get the story, to get their version of events. And, at the same time, you know what I mean? Like, I know the documents in the case when I'm there, you know what I mean? So if I say, did my client ever, complain about mistreatment by so-and-so? And they go, no, but I've got a text message from my client to that supervisor complaining about it. I can go, well, hold on a second. Let me show you this text message that I have. You know what I mean? I slide across and I go, she's complaining about it, right? And sometimes they'll go, yeah, I guess she is. So I'll go, so in fact, she did complain about it, correct? And they'll be like, yeah, I guess. And I'm like, well, are you guessing, or are you sure? Because we're looking at the text message. And they'll be like, yeah, she complained. So, so you're trying to get the information in deposition, right? But at the same time, I know the story, right? I know the documents. And if they contradict one of those, I'm going to hit them with it. You know what I mean? Like, I am going to present that to them and go, I don't think you're being truthful.
Yeah. Oh, this is awesome. See, this is the type of stuff we need as employees. As employees, you need this information.
You've got to know. And look, I mean, depositions can be intimidating, right? They can be a little stressful, but I'm a proponent to my clients, go in there and just tell the truth. I mean, if the truth is on your side, you're not going to get tripped up.
Exactly.
You're not going to get a document slid in front of you that goes, oh yeah, you're lying. Look at this text message. You know what I mean? If the truth is on your side, you don't need to lie. And if you
Yeah.
don't lie, your credibility is not going to take a hit, and they're not going to be able to make you look like a liar in front of the jury when you eventually get to trial.
Yeah. And it's another thing, the biggest thing from I'm really taking away is you have to document all the things that are happening and make sure you're actually communicating with your bosses or the owners of the business, letting them know what's really going on, because all that stuff matters if it gets to the degree where they're hiring a lawyer. And
yeah, you're right. You're right. That document, right? It comes back to that, because if I'm sitting in deposition and there is no document that shows that my client complained, and the employer goes, no, she never complained to us, I'm kind of stuck. You know what I mean? Like, I can't say you're lying, and my clients, sometimes they write down in Post-it notes. They're like, he's lying. And I'm like, I get it, but we can't, at this stage, we can't prove that, right? It's going to be up to the jury on who do they believe. Do they believe you, or do they believe him? You know what I mean? That's going to be it. But if I've got that document, if I've got that text message or that email, I can go, oh, she never complained, huh? Whoop. Slide it right across the table and go, what's this document?
Okay.
This is an email that you received where she's complaining about it, right? And, boom, then it's really definitive proof that she complained about it.
Yes.
And so you're right, man. It comes back, Travis. Document. I mean, documents are a lawyer's best friend.
Yeah. And I think it's just a personal, like for a person receiving mistreatment at work or having issues, document protects yourself, and it can position you to be in a better situation, or not in a worse situation if you were to get fired, or if you're dealing with these type of issues at work. Because it's really stressful. I know what it's like to deal with someone you do not like at work. You feel like they don't like you. You feel like they're just trying to get you fired. Dude, that's like the worst feeling ever.
We've talked about that before, right?
It's the worst.
With past experiences. And
yeah.
And look, with the document, it's important to point out that it doesn't matter really in a lawsuit what happened, right? It's what you can prove.
Yeah.
Because you could say this happened and I complained about it, and they could say, no, it didn't. And for some reason, a juror could go, yeah, I believe the employer. Yeah. I think if I was an employee and that happened to me, I would have put it in writing.
Yep.
And there's no writing. So even though it happened to you, a jury could find that it did not, just because you haven't met your burden of proving that it did.
Yeah.
Because you've got the burden, right? As a plaintiff, I mean, we have the burden of proving something happened, more likely than not. So 50.00001%. If you've got a, scale at 50%, we just have to go, and raise that one side just a hair. But it's our burden. And so if you've got it in writing, that's a big help. Big help.
All right, perfect. So that was that's the deposition. So they've gone to the
yeah, that's the discovery phase, right? The written discovery and the depositions.
Okay.
So that's discovery, and then there may be some law in motion sprinkled in, like a motion to compel certain discovery. Like if somebody asks, for something private or confidential, and the other side's like, I'm not turning it over, and the other side's like, yeah, you better. Sometimes the court has to get involved, and the judge has to go, yeah, you get that or you don't. So there's some motion work sometimes, but that doesn't really involve, the clients very much at all. That's kind of the lawyers working behind the scenes. And so that's discovery. I mean, that sort of wraps up the discovery phase. Along with the law in motion, there's sometimes in these cases a motion by the defense to dismiss the case, right?
Okay.
Saying, judge, look, even if you believe everything, that Mr. Hanrahan's client is saying is true, even if you believe every bit of it, it still does not support a lawsuit. You know what I mean? It does not support the claim, so there's nothing for the jury to decide.
Okay.
So if the judge grants that, case dismissed. But if the judge doesn't, and all we have to do is show that there's an issue for the jury to decide. That the jury has to decide what happened and and who's right. So if the judge finds that there's a tribal issue, then it's like roadway is cleared for trial. And then so if the case doesn't settle at some point during the litigation, which it can at any time, if it doesn't though, then you find yourself in trial, and you're presenting the case to a judge or a jury and trying to convince them that your version of the case is the correct one and you should win. And the defense is trying to, convince them and persuade them that their version is correct and you should lose.
Wow. And then is there like a typical amount of time how long that takes?
It used to be in San Diego, we used to have a fast track system. So from the date that you filed the lawsuit, you would have a trial date within 1 year. So within 1 year, fast track kind of went away. It was kind of, the courts were too busy. It was starting to become 12 months, 13, 14, 15, 16. COVID hit. There was a big backup. Now I tell my clients, if the case does not settle and you go to trial, that we could expect a trial 1.5 to 2 years from the filing date.
Oh, wow. So it's a process.
So roughly, it's a process.
Okay.
It's a process. Now, the case can still resolve at any time. You know what I mean? I've had cases resolved during trial. You know what I mean? While you're in trial, and then the sides are just like, for whatever reason, maybe it's not going great, still exchanging numbers, and you get the case settled while trial's going on.
Oh, that's nice.
Cases settle after trial. Like one party could win, usually the employee may win. And then, maybe we'll do a motion for attorney's fees or something additional. And the other side comes and just says, hey, look, we'll just pay you this much. Let's just end it. So settlement's always a possibility at any point throughout the case.
Okay. Awesome. Let's see. Okay. So that's discovery. Then we went to depositions. And then following the depositions, what would be the next step after that?
It would really be possibly the motion, to get the case dismissed by the other side and then trial. So, the phases really, the way I see them, are the pleading stage, right? Discovery, trial. It's sort of a grand overview. Those are the 3 stages, of really any lawsuit.
Okay. Oh man, that was very informative. That was very, very informative. It's funny because you do this all the time, so it's so basic. But these basic things is what people need to understand, that I believe, because this basic information, the right person can hear this. And I hope this helps just one person that can hear this and go do something about it, and gives you the confidence to go, you know what, at least I'm going to start documenting what's going on. I'm hearing this. I've heard this before. I haven't heard this before, and it makes sense. Let me tell my cousin who I've heard was dealing with this, or my sister, or my wife, or if you hear someone dealing with this, this is good information.
Yeah, share the information. Share the information with, friends, loved ones. Shoot, share it with your enemies. Seriously. Who knows when they're gonna need it? But just sort of taking that fear and the unknown out of the lawsuit. That's what I wanted to do with this episode, right? It's just perfect. To tell people what to expect. And you've got a lawyer with you every step of the way. You know what I mean? Like it's not scary if you've got someone with you representing you along the way that knows what they're doing. You know what I mean? Like I have fun with my clients. We're laughing, we're joking. It's, I'm a pretty easy fella to get along with. And so, you know what I mean? Like my clients and I end up being friends a lot of times. You know what I mean? I'll get text messages and emails and Merry Christmas, Happy Thanksgiving and all this stuff. And we exchange things because, over that 1.5, 2 year span, you get kind of close, you know what I mean? And it's, it's tough not to sort of become friends in a way. But yeah, if you've got a lawyer, who knows what they're doing and is looking out for you, that litigation process is not scary at all. There may be some, difficult times. There may be some times that are a little bit more stressful, but it sure beats just letting that unlawful behavior by the employer go unchecked. You know what I mean? So that they can do it to the next person and just keep doing it because no one's calling them out.
This is great. This is great, Corey. I think we've flooded people with enough information for this episode. What do you think?
I think so. I always plan on keeping the episodes kind of short, and then we start talking, and I feel like we could do another hour if we wanted to, but people are sleeping by now.
Thank you guys so much for tuning in. Again, you need to flex your rights, and by listening to Flex Your Rights, you can have all the ammo and all the machines for your muscles and your confidence to do something and stand up to those employers that are treating you wrong out there.
That's it. Having that knowledge to know when something's happened to you so you can go and find a lawyer to, get the employer to shape up. That's knowledge is power, and that's what Flex Your Rights is all about, right? But you got to know them so that you can flex them, because if you don't know them, you can't flex them.
Exactly. And you guys have a great freaking day today. Be amazing. Enjoy if you're at work, I hope you have a great day at work, and I hope your boss is treating you well.
Absolutely. Absolutely. Everyone have a great day. Thanks for tuning in. We'll drop another episode soon as Travis and I can connect again. And we appreciate you all listening. Take care.
Oh yeah, and one last thing too. Corey has these really cool shirts for sale on the link in his bio. So if you want to wear some shirts like this and put a little fire underneath your boss's butts, go buy one of those shirts and throw one on.
I know my rights. Yes. And reach out on social media. If you reach out on social media, connect with me. We'll figure out a way to get you a shirt. So, you can find me, at Attorney Corey. My website, hanrahanfirm.com. You can also go to attorneycorey.com. That's COREY. That'll forward you automatically to hanrahanfirm.com and find a way to get in touch with us. If you want a shirt, we'll find a way to get you a shirt.
You guys have a good day today.
All right. Thanks all.
Thank you for listening to Flex Your Rights Podcast, the podcast to educate California employees so that they can flex their rights in the workplace. If you'd like to reach out to me to ask me any questions about today's episode or make a suggestion for a future episode, you can find me at attorneycorey.com. That's attorneycorey, COREY.com.